Marbury v. Madison, 1803, establishing judicial review. In the early 19th century, the United States faced a pivotal moment in its legal history, a case that would define the powers of the judiciary for generations to come. This case was Marbury v. Madison. On one side stood William Marbury, a Federalist who had been appointed as a Justice of the Peace in the District of Columbia by then-President John Adams during his final days in office. Marbury: Your Honor, I have been wrongfully denied my rightful commission by the new administration. I seek to compel Secretary of State James Madison to deliver it to me. On the other side stood President Thomas Jefferson, who was determined to block Marbury's appointment as part of his political opposition to the Federalists. Madison: Your Honor, Marbury's commission was not delivered, as my duty is to uphold the decisions of the new administration. Chief Justice John Marshall, himself a staunch Federalist, faced a delicate balancing act, upholding the law while avoiding a direct confrontation with the Jefferson administration. Marshall: The question before this court is whether Marbury's commission should be delivered. But there is a larger issue at stake, the Constitution itself. In Marshall's historic decision, the court held that Marbury did indeed have a legal right to his commission, but that the law under which he sought his commission was unconstitutional. Marshall: It is emphatically the province and duty of the judicial department to say what the law is. If a law conflicts with the Constitution, it is null and void. This groundbreaking decision established the principle of judicial review, the power of the courts to review and potentially invalidate laws that violate the Constitution. Marbury v. Madison marked a turning point in American jurisprudence, ensuring that the judiciary would serve as a check on both the legislative and executive branches, and solidifying the role of the Supreme Court in shaping the nation's laws and values. Marbury v. Madison establishing judicial review.